Welcome back. You're watching HFO-TV, co-sponsored by AMF Capital, the Baljanik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Welcome back to HFO-TV. I'm Greg Frick, partner here at HFO Investment Real Estate. And today on HFO-TV, we're going to talk to Brad Kraus. He's an attorney with Warren Allen. For those that don't know, Warren Allen's one of the big attorney firms here, kind of a landlord-tenant law attorney. So today we're going to talk about, thank you for coming.
Appreciate you having me.
You know, 608 passed, SB 608, which was the statewide, Oregon was the first in the nation to have statewide rent control. Congratulations. There are some exemptions and qualifying exemptions, so we're going to talk about that and then some other things that have happened kind of in the law changes. So again, thank you for coming.
Appreciate you having me.
I know our clients and viewers really appreciate the ability to hear somebody kind of dive deep into this topic because, you know, if you try to read that bill yourself, your kind of head spins.
It'll definitely cure your insomnia, I will tell you that.
Yeah. So let's just jump right in. There are, so under 608, there is, you know, an existing tenant, you know, you can only raise rents. I think they just reset it now. I think it's 9.9. 9.9. It's 7 plus CPI, and CPI went down this year. So it sets in, the CPI comes out in September, and it's effective for the preceding January.
Yep.
Okay. So there are some exemptions or qualifying exemptions for repair and renovation under 608 where you're not under that guideline. Maybe we can dig a little deeper into that.
So with regard to the guideline on the repair exemption, what we're focusing on there is not so much the rent increase, but it's let's say you have a tenant who's month to month,
right,
and they've been there for more than a year.
Which is one of the key parts, that they're there for more than a year.
So the first year of occupancy is the real key point there. And again, this is solely focusing on the state law. Local jurisdictions like Portland obviously have
their own deal.
But solely focusing on Senate Bill 608. If you're in that first year of occupancy, which has a specific definition in the statute, you still have your no-cause rights. After you get past that first year, Senate Bill 608 has extremely curtailed landlords' rights in terms of service of no-cause notices.
Right.
And that's where the exemptions kick in, the qualifying landlord exemptions. And one of those, as you had mentioned, is the repair renovation exemption. And if you want me to elaborate a little bit more on that.
For clearing, so if I've got a, and again, from when they say first year, it's not the first year of their lease, it's the first year they're physically, so if you're renewing on an annual basis leases, that doesn't count first year. The first year is the first time they've actually occupied the building.
Yeah, so we're not definitely not focusing on the renewals because again, the first year of occupancy is
when that existing tenant.
The first year of occupancy is the first year that all tenants have lived in the premises. So if you've got sort of roommates coming in and roommate additions, things like that, that can change and sort of reset that first year of occupancy.
Gotcha. Okay. So there's what about relocating the tenant within the building? Does that reset? If I've got a tenant in a one-bedroom, they end up needing a two, we move them from one unit to another. Does that reset occupancy, or is that still a gray area?
So the tenancy itself, if you'd move them to a new unit within the complex, to me it would reset. Reset a tenancy.
Okay. Yeah. So then again, we're talking after they've been there a year. We've got some repair. We want to do an extensive repair. We have a major issue. What does that kind of look like? Yeah,
so if the landlord wants to invoke that qualifying landlord exemption, what you're looking at is effectively a 90-day notice.
Okay.
And that notice has to specify the facts supporting the exemption. And the exemption, the repair renovation exemption, requires that the premises be unsafe or unfit for occupancy, or that it will be unsafe or unfit for occupancy
during
yes, and that the landlord intends to make those repairs or renovations within a reasonable period of time. And a couple of key points there. Obviously, a reasonable period of time, not really defined in statute. I would say within a month, definitely makes that happen. But the unsafe and unfit for occupancy situation is interesting because it almost forces landlords to think like tenants. When we file eviction actions for, let's say, non-payment of rent, oftentimes we face defenses or counterclaims that the premises is uninhabitable. And there is a particular statute in the ORLTA, 90.320. It's sort of a landlord duty statute. It says that the premises has to not substantially lack any number of things. And when you're thinking about the qualifying landlord exemption for repairs or renovations, to me, I'm looking at that statute and saying,
if they can't meet this,
is the property going to lack any of that? And the way that I sort of think about it is, how miserable is it going to be living there during these repairs or renovations? Is it going to have plumbing? Because let's say you have a property that only has one toilet. Well, I think any tenant's attorney would argue that if a property doesn't have working plumbing or a working toilet, it's completely uninhabitable.
Right.
Okay? So if you're going to do just repairs on, let's say, one bathroom, and the premises still has a separate bathroom, a crafty tenant may be able to say, yeah, this place actually isn't unsafe or unfit for occupancy. So they'll sort of use that against you. It kind of creates an interesting dynamic where we sort of flip the script on the landlord-tenant claims defenses sort of thing.
What are some of the, there's some, with the regulations, some strategies in terms of if I've got a bad tenant? I mean, not that there's, everybody's had stories.
Yep.
What are your strategies or what's your recommendation on how to deal with that, in the new kind of environment that we're in?
So most of my day-to-day involves folks calling me up and saying, Brad, I've got a bad tenant. How can I get rid of this problem? The main focus is first off on your rental agreement.
Right.
Focus on the rental agreement because that provides really the backbone for what the tenant's obligation is. And being able to point to something that they're not doing.
Within the rental agreement?
Within the rental agreement or statute. There is also a tenant's duties statute, but the tenant's duties statute is pretty bare bones. Doesn't deal with anything that says you can't smoke other than the quiet use and peaceful enjoyment portion of that. Doesn't say anything about pets, doesn't say anything about unauthorized occupants. A lot of those are the things that landlords deal with. The main thing that you can do is really focus on gathering your evidence. So obviously you're going to need to prove everything that you put in the notice. So if you say that somebody is causing noise at 2 a.m., you better be able to prove that that individual is causing noise. So chatting with the neighbors, getting accounts from them.
Do you need like a signed statement from a neighbor?
So a signed statement is great because you can put that in your file and now you know who you need to talk to. But when it comes time to file an eviction action, and let's say the guilty party is saying, I'm not doing any of that, it's not me, you're going to need that individual, the complaining individual, to testify about what they heard, because that signed statement is hearsay. The court's not going to receive it.
Which is where we've talked to a lot of owners who were using no cause for trying to prove some of the stuff, an unauthorized occupant.
Yep.
I mean, are they watching everybody going in and out of the unit, and how do you even? Yeah.
Unauthorized occupant situations are the most difficult to work with because, as you just don't have cameras in someone's unit to be able to prove things. So the way that you're able to do that a lot of times is through neighbors' testimony saying, I see this person, they're there every morning, they're there every night, I know what car they drive, I see their car parked there every day. And oftentimes, a lot of situations, if a person's living there for a while, what we can do is we can look in, let's say the DMV or maybe the court registry and see what they're saying their residence is. Yeah. So that is helpful. And really, the unauthorized occupant situation is only really a problem if the unauthorized occupant is causing a problem.
Right.
Otherwise, the landlord's likely not going to know about it, or frankly, probably care.
Right.
Because all landlords want is good tenants that don't disturb anybody and pay their rent. But yeah, the unauthorized occupant situation, difficult, completely understand it. The main kicker is that, and this is what a lot of landlords forget, you need to really focus on your rental agreement and the amount of time that your rental agreement says.
Allows for that.
Allows for a guest to be there, because if your rental agreement says that person has to be there for 14 consecutive days in order to be qualified as an unauthorized occupant, you better be able to prove that they've been there for 14 consecutive days.
Which is something we've been talking to a lot of our clients is with everything that's happened the last few years in Oregon and Washington, you've got to make sure your rental agreements are up to date. I mean, that's, I think, we've talked about this before, is putting you guys in a position to try to do something with a rental agreement that's 6-7 years old.
You would be shocked at how much the laws have changed in the last 6 or 7 years. And one of the biggest things that has changed is the post and mail sort of battle, so to speak, when it comes to like serving a 72-hour notice and not adding 3 extra days for mailing. So you just use a flat 72 hours. And you elect to post and mail that notice. So you post it to the main entrance of the dwelling unit and mail it first class mail. Well, the language in rental agreements has been challenged pretty frequently, and it is a pretty standard challenge from tenants' attorneys. Most of the time, the post and mail language in these rental agreements is just fine, but we have had some rogue sort of judges that have, not really interjected a level of common sense into a reading of the rental agreement, and that does present challenges. The way to get around that and the way to not have to deal with a post and mail challenge is simply to add the 3 extra days for mailing and just have a 72 hours plus the 3 extra days for mailing. But again, the post and mail language is a great example of how much the language of these rental agreements has changed over the last.
And if you're not keeping up to date on those, you're setting yourself up to having some issues. Hopefully you don't have an issue with a tenant, but it should something happen, and it's like you said, it's on the owner or the landlord, property owner is the one that has to prove whatever it may be, and it's all going to go based off of the rental agreement and the statute.
Absolutely, and in an FED setting, an eviction setting, we have the burden to prove everything that we allege. So we have to prove that the notice was good, that it was validly served in accordance with Oregon law, and that the rent, let's say it's a 72-hour notice case, that the rent remains unpaid. A lot of those are pretty straightforward, just factual statements from the landlord, but when you get into real technicalities, which tenants' attorneys love to do, because they're fighting for their clients just like we're fighting for ours, and we obviously have a lot of respect for that bar because they are intelligent and they shape the law as well. But most of these up-to-date rental agreements are sort of vetted through that fire, right? So they're made and vetted by attorneys that have gone through these battles, and they can really help you stay ahead of the game.
And I know there's some potential changes coming in Portland next year in March. There may be challenged in terms of background security deposits. I think their acronym's fair housing. So I'm sure you guys are gearing up to be quite busy for that.
Yeah, so the FAIR ordinance is coming down the pipeline here, along with changes to the security deposit. Most of those, I think, we're still working through them and still putting together materials on them. But if anybody, once we get those together, obviously the barrage will come in, and we'd be happy to help anybody that needs assistance with that.
And they can get the information at the website below. And again, you guys do a lot. It's the practice is prominently landlord, property owner practice in terms of landlord tenant.
Absolutely. My practice is primarily about 95% landlord-tenant law.
Got it. Okay.
All on the landlord side. And then the remaining 5% is civil litigation based. But my entire firm is all landlords. We represent only landlords.
And do you do Oregon, Washington, or is it just Oregon?
Oregon and Washington.
Okay.
Yep.
And prominently in the 4-county area, Portland, PMSA?
Yep, it's the Portland, Washington, Clackamas area is kind of where we do the bulk of our work, but we have clients all over the state of Oregon, and we also have clients all over the state of Washington. So wherever your property is in these 2 states, we can definitely help you.
And is it just kind of, what are you seeing kind of moving in the next few years? Do you think the pendulum's going to continue pushing on the way it's been pushing, or are we sensing maybe, I don't know about political, but maybe in the court systems that it's getting a little... Well, what's your take on that?
I'd certainly hope that the pendulum couldn't swing any further than what it has.
Yeah.
But being around this for as long as I have and for as long as most of the attorneys in my firm have. The pendulum does tend to swing one way and then it tends to slide back a little bit.
Right.
In Portland, I don't see it sliding back anytime soon. Right. I will say that. At a statewide level, it does seem like at some point in the future here, hopefully, common sense will prevail a little bit and will swing back a little bit. But right now, we sort of are where we are, and we have to deal with it. Just as a closing remark, what I will say is remember that the state law is but one set of laws. You also have to remember that local jurisdictions like Portland do have their own set of rules. So simply because you can comply with the state law
doesn't mean you comply with
doesn't mean that you can comply with Portland. So they're two separate distinct things, and you have to analyze them both.
Gotcha. Well, thank you for coming, and I would say to the audience, keep looking at HFO-TV, or we'll be sending out information as we get closer to March as to what's really happening with the fair ordinance in Portland, because that's significant changes. I mean, you've got security deposits, you have security deposits, background checks, criminal checks, how you got to do your applications. That one's really kind of geared towards not your existing tenants, the tenants coming in, and how you're going to conduct business and filling units. There may be a court challenge that's probably going to happen, but when that gets filed, we'll see, and we'll keep everybody abreast of that. But again, thank you. And the other important thing, please update your rental agreements. I think that's makes your job much easier if you do have to go down that path. So again, thanks for coming again, and we'll talk to you again on HFO-TV.
Thanks so much.
Thanks.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.